Okay, I think it is 6 o'clock. Time to call the meeting to order. First, we could have the roll call, please.
Brown,
Present.
Hennigy,
Present.
Nibbs,
Here.
Marshall,
Here.
Shaw Null, here, Stein, here.
Okay, next item is the approval of minutes, the first one being May 6th, 2025, the regular meetings. Consider a motion to approve.
I will read that. That's it. I'll make a motion to approve. Oh, second. The May 6th, 2025 regular meeting minutes.
Thank you. All those in favor?
Aye.
Any opposed? Okay, next item is the approval of the closed session meeting.
I move to approve these minutes.
I'll second that.
All in favor?
Aye.
No one opposed? All right, next
Those
item,
facts.
I'll get them at the end of the meeting. That's okay. Thank you.
next item is public comment. If there's anyone with any new folks, anyone online who would like to comment on something not on the agenda? No, there being none. Okay, so let's go to old business case number H74, the Powell application on remand. Consider whether there was a vested right in operating a short-term rental on the first floor at 215 West Mitchell Street prior to the enactment of the new ordinance. Lisa, would you like to fill us in on any background information?
Sure. So this case was brought before the ZBA in 2024 for an appeal for a short-term rental in April of 25. Excuse me, let me back up. July of 24, the applicants appealed to Emmett County Circuit Court, and on April 7th of 25, Emmett County Court found that under Article 10, Section 1001, a short-term rental was permitted use on the first floor in the B3 General Business District, and remanded the case back to the Zoning Board of Appeals for further consideration as to whether the property owners established a vested right in operating a short-term rental on the first floor of their property prior to the enactment of the new ordinance that the city had passed in late 2024. The ZBA's remand hearing, this hearing is to evaluate whether the Powells established a vested right to operate a first floor short-term rental prior to December 18, 2023, based on the standards in Heath Township versus Saul. This requires work of a substantial character beyond mere preparation that materially and objectively changes the land itself toward a lawful use before the zoning change. There is case law that is included in your agenda memo that is cited in reference to this as well. And it's being asked, the court is asking the board to consider again whether or not the applicants established that vested right prior to December 18, 2023.
Do you want to read the action? Or did we already do that? No, not yet. Okay, so just since I'm a newly elected chair, I just wanted to add some organization to this meeting. So first, I think if we have Mr. Zayas and the Powell do their presentation, and then after that's completed, it will come back to the board members. If you have questions for Mr. Zayas or the Powells, that would be the time to ask them. I don't know if we can limit questions to prior to our discussion. Is there any regulation about that?
Laura, can you answer that question?
Oh, Laura, of course.
Oh, are you mute? Oh, sorry, let me. Sorry, I forgot once you go out, you can't come back in.
Right, so I might mute myself during this and you might need to unmute me when I'm speaking, but no, you have flexibility in how you run this. So you can decide when and how you want to take questions and be, flexible in that as might be necessary or appropriate to make sure you get the information that you need.
Okay.
So,
Point of order,
I'm sorry,
a point of order.
yes.
Do we need to revisit the entire court case and the original application, or can we just move on to the request by the court to review their vested interest?
So it broke up there during your question, but I think I got the gist of it. The court's remand was fairly narrow, and this is under the action language in the staff memo, where the court has already made one finding, which is that under the zoning ordinance, a hotel was a permitted use on the first floor in a B3 zoning district, and no approval from the planning commission was required for that purpose. So it would not be appropriate for the ZBA to revisit that issue. What the court did remand it for is in that second paragraph where the court said, with said understanding, this matter is remanded to the Zoning Board of Appeals for further consideration as to whether the applicants established a vested right in operating a short-term rental on the first floor of their subject property prior to the enactment of the new ordinances. So what we're focusing on really, and Mr. Zayas can, give his perspective as well. But in reading the decision, it's really a factual determination for the zoning board of appeals to make as to whether there was work of a substantial character on that first floor. So breaking out what work was done on the first floor versus other parts of the building, for example, and what those expenditures were, and whether that is sufficient to be work of a substantial character. And then discussing the role of building permits in that. And I think getting an understanding from the Powells and their counsel about what permits were or were not obtained and what their understandings were. Because under the case law, which we've at least summarized in the memo, certainly if you have a building permit or other certain permits and work of a substantial character, that has some legal significance. But here there's certainly question about what permits were or were not obtained. And I think that's part of this, that is, I believe, part of this remand hearing as well, is to flesh out the facts surrounding the permits.
Did that clarify that for you?
Yes, thank you.
All right, anything else? So, Mr. Zayas, is it Zayas or Zayas? I'm sorry.
Zayas.
Zayas, sorry,
Yep,
it's
no
pronounced. You first.
Sure, thank you. I'm sharing my screen so you guys can see the PowerPoint as we go through it. Am I up there?
No.
Well, that's,
You run in. Let's see if you're still. Oh, you're not connected anymore. You have to log back into the. Zoom.
apologize, I had it up, all set to go about 5 minutes ago. Must have kicked me out,
Technology at its finest.
yeah. Yeah. You didn't know John was a teacher, which is funny. Yeah. Has some experience with trying to.
The handouts weren't a clue.
Yeah. Okay, so,
we're waiting for that to join, I do have some points to make, I guess, before we get to the PowerPoint. So let me try to be a little bit efficient with this and
You move down.
I'm sharing up there. Ready. Okay, so.
Wait, that's not showing the presentation mode.
Yeah, it's not following me, I don't know why.
That's.
Frozen.
So I have a heavy file that might be live, so.
All right, I guess let's let it download and then we'll return to it. Hopefully we can walk through it. If not, we will, again. So anyway, as you heard, my name is Joseph Zimes. I represent Mr. and Mrs. Powell. I appreciate everybody being here today. And we're back here for the second time, almost a year to the day, actually. And frankly, the Powell's request has not changed. They want to run their business. That's what they wanted when they bought the property. That's what they wanted when they renovated the property. That's what they wanted when they tried to work with the city and the county to get the licenses and permits they needed. And that's what they're asking for today. That has not changed. What has changed is the circuit court has determined that contrary to what was previously asserted, short-term rentals were actually allowed on the B3 on the first floor of the B3 district. The reason this is important is because Mr. and Mrs. Powell, unfortunately, were run through the ringer being told they couldn't do that. Turns out that wasn't true. So we're back here again today. Now, the fact that that requirement was unduly imposed, even though it didn't have a basis either in the ordinance or in county precedent, I think should give both this board and everyone involved pause. But onto the issue at hand. So we're here today to specifically determine whether or not they have a vested right. Now, to have a vested right, essentially you have a prior non-conforming use. What that means is that essentially you were, or at least started the process of using or turning the property into whatever you want it to be, in this term, a short-term rental, before an ordinance change. So we know that under the old ordinance, they should have been permitted to operate a short-term rental in their building. The court has decided that already. Now, if the city had taken that position, they would have had all the licenses and everything else they needed long before this moratorium came into place. Nonetheless, what they did do is start the process, at least, of turning that first floor into a short-term rental. So we heard a little bit from council about what that means, what having a vested right means, and it's work of a substantial character. Did you tangibly change the property? Now, you don't have to actually start running a short-term rental. You don't actually have to have it done. The question is, did you change the property? So when you see the summary of case law, when you look through those cases and actually read them, what you'll see is simply planning isn't enough. And most of those cases deal with things where the applicant didn't actually do anything with the property, or at least didn't do enough with the property. So, we have cases where they bought plans, they did surveys, they did a whole bunch of stuff and probably spent a whole lot of money considering some of those are expensive commercial developments, but they didn't actually change the nature of the property. In this particular case, I think you'll see, and I'm hopeful that we can get this up and running, because the pictures and the videos, I think, demonstrate that what the Powells did was change the nature of the property. Now, if you'll permit me, and I didn't intend to do that. But I would like to talk about permits a second, and I'll return to it in more detail later. But when you read the cases, certainly permits are considered. That's true. But it's not a bright line rule. So you're looking at essentially a progression of changes to the property and work being done. And what the courts are trying to answer and what this board has to try to answer is, did they get far enough on this progression to actually qualify to have that vested right? And one of the kind of signposts, mile points on that progression is, did they get to the point where they needed permits? And then did they get those permits? Now, I'll get to the back and forth with the city and the county and all that stuff in a second regarding the permits. But I think it's unquestionable that they at least tried to get the permits. Unfortunately, their contractor didn't do what he was supposed to do. He presented the paperwork. Mrs. Powell asked them, excuse me, I apologize for my voice. I have a bit of a cold. Happens when you have 3 kids in school. They tend to bring things home. She presented the paperwork to Ms. Powell, said he was going to get the permits. Turned out he didn't get the permits. My point being, for the purpose of our discussion right now, they certainly got to that point of permitting the thing, and they actually started construction. And that's really where I'd like to kind of walk you through, if I could. And I don't know, Lisa, have we gotten any closer to trying to get this figured out? As far as, am I in there?
You're not back on there again.
They kick me out again?
The internet keeps kicking you off.
Yeah, for some reason I'm getting kicked off your Wi-Fi here. I'm not sure why.
Can try to access the Zoom too if you want me to just navigate it as you talk. I'll try to do it.
Give it a shot.
Honestly, yeah, just so Steve gets there first.
Exhibit 1 is in their hands as well too.
Yeah, that's also, we also did a handout, so I guess let's get to some of the finer points. And really what the well, I always bring a paper back up to court. Mallory will work on trying to get water in there.
I'm in there, so I don't know what I would need to do to be able to share my screen.
I just sent you you should get a request for it.
So the charts that Mallory was nice enough to prepare go through the expenditures and different things that were spent in the year and then on each floor. And what you need to understand is minimal things, mostly cosmetic things, were done on the second floor. So most of, if not close to all of, I think it's over 90% of the work that was actually done on this was done on the first floor. So when you see these expenditures, most of them, I won't say all of them, but most of it was the first floor, because the second floor was already a residence. Essentially, you had something that had been a print shop and then office space for years on the first floor, and then a residence on the second floor. So the second floor really didn't need the massive changes that the first floor needed. So when you look at these expenses, most of these were done on the first floor. And I'll note that it's true that the case law says that simply spending money isn't enough to prove that to right, and that's true. But what the money is evidence of work being done. So when the case law says that, it's essentially saying, well, these guys who are doing these big developments spent hundreds of thousands of dollars on an architect to do these plans. Just spending the money is not enough. You actually have to change it. Here, what we have is money actually paid to a contractor to change it. So it's certainly evidence of work being done. And it looks like Mallory's got us up and running.
All those years of being a wedding planning.
So she has the well, that's the first slide with the money. The next one shows the contractor invoices. But what I encourage you to certainly look over the divisions of what was being spent. I think if you look at page 5, now I can go to page on one map. That has the breakdown there. It says 93% was spent on the first floor. Second floor was mostly cosmetic. Emergency repairs to the structure and some outdoor stuff was the rest. So most of that money being spent was spent on the first floor. But to really get to the crux of this, I want to skip ahead. And what I want to skip ahead to is page, I believe it's page 20. Now, all this is in your packet, and I'll, I emailed this to Lisa, and I, encourage you to go through and look at all this stuff. But starting on page 20, we talk about actual updates to the first floor. So here's what we're talking about. What was actually done? And you'll see a before and after floor plan of what the work that was supposed to be done. And you can see this is more than just cosmetic stuff. We're not taking an office and putting a bed in it. We're actually changing the nature of rooms themselves. And you'll see on the left-hand side, there's actually a list of things that were completed or in progress. So a brand new wet bar and a kitchenette was done. Full renovation to a two-piece commercial bathroom and adjacent space was started, was in progress. They created 2 new bedrooms, a 3rd bedroom and a 4th bedroom. That was done. These are tangible changes to the property itself that were done. This isn't just, I went and got plans. These are actual changes to the property itself. Full renovation of a bath that's in progress, and when we're in progress, we don't mean that it's something we plan to do in the future. We mean that actual work has been done on it, it's just not finished yet. They also renovated a wet bar and a private office space, which is now a bedroom, and replaced it with a basin sink. That's complete. Again, tangible changes to the property itself. Now, I'll note, it doesn't have to be complete to be tangible property, but what it needs to do is somebody looking at it has to say you actually did something with your property. So if you look at the next page, if you want to go move forward, Mallory, those are some of the pictures we have of construction. You can see walls being inserted, you can see the floor being torn out, bathrooms being put in there. You see actual things that were changed. We're not talking something that was, pie in the sky and good day, this is what we want to do. We're talking about things that were actually changed. So work of a substantial character, if you will. Living room, your specific pictures on page 24 show the living room and the kitchenette. Want to go forward there? Oh, there we go. The bathroom, before and after. And she's even been nice enough to circle on that where it was in the building. You see the updates that were done on the left-hand side. Mallory, frankly, is much more helpful than most of my clients. I think did a wonderful job with this. Usually I get clients that show up with Polaroids, and so definitely thank Mallory for the professional job that's being done here. New guest room corridor on page 27. The second bathroom, there's a new guest room corridor. New bedroom 1, before and after pictures. You can see new bedroom 1. You can see that the nature of the place, the space itself is being changed. These are tangible changes. New bedroom 2, the next slide. Now there's also updates to the exterior that are being done here before and after. All done specifically to the first floor, but all done in an effort to forward this vision that Mallory and John had of creating an upscale short-term rental that can be used for people with large groups and pets in Petoskey. And that was really their vision. That was their business plan. They saw a need in the city for these large rentals that can accommodate large groups and be welcoming to pets. They're dog owners themselves, and wanted it so people know how hard it is to try to get a hotel room if you want to bring your pet, and they also know how great it is to try to walk your dog in this town. So naturally, there's an opening there, and that's what they wanted to do. And as you can see from those pictures, I think it demonstrates very clearly that they took substantial steps. They changed the character of the building from this, bare office space, raw maybe is the word I should use, office space, to a short-term rental. That creates a vested right. That creates a prior non-conforming use. Now, the court's already said that they had the right under the old ordinance to run a short-term rental on the first floor. And the fact that they've gone this far to do that prior to any moratoriums and prior to any actual changing of the ordinance, which didn't happen until December of 23, I believe, demonstrates that that right vested operate that short-term rental. Any decision should be made, essentially what they're saying is not that zoning doesn't apply, but that the old ordinance applies. So if the old ordinance allows them to run a short-term rental, then they should be allowed to run a short-term rental. Because essentially they're grandfathered in under the old ordinance. That's what we're saying. And because they went that far towards transforming the property, they've essentially established themselves as a vested right. That's why we would ask this board to find that they're a vested right and overturn the decision of the zoning administrator, finding that they were permitted to run their short-term rental on the first floor. Now, the city has argued, at least in the appeal process, that the fact that they didn't have permits prevents them from claiming that they were a vested right. As I've kind of hinted at before, it's not really the case. Now, it's true that a lot of courts have certainly considered where permits are, and they've looked at where in this progression they are. And if you haven't gotten to the point of needing permits yet, they've generally said, you're not far enough. But it's not because they want to create a bright line rule to say no permits, none. And one point, no, you can't be a vested right. And one point I want to make is that this board is not an enforcement body of the Emmett County Building Department. Whether you think they should, or whether you think they appropriately didn't get permits or should have gotten the permits, or whatever your view on it is, it's not your job to enforce the building code. And therefore, it's not your job here today to, issue some kind of punishment because you feel they should have gone and got the permits. The question before you, and when you read the cases, the courts always come back to this question, is did they do work of substantial character in order to change the building and do that? And one point along that progression is whether or not they got to the point where permits were required. Now here, they certainly got to that point and further. And we're working with the Emmett County Building Department to try to get the permit issue solved. And I'll touch on that a little bit as we go on. But the important point is it wasn't, thumbing their nose at the county. It wasn't, we don't feel we need permits. It wasn't trying to make some sort of, libertarian point or something. They thought the permits were there. Their builder essentially defrauded them. And it should be noted, I don't know if we reviewed the transcript from the hearing, that while the court didn't make a decision on whether or not the permits were required or not, she certainly asked pointed questions to the city's council at that time when she was making this argument regarding whether or not they were required. No, I'm not going to presume to put words in the judge's mouth or say she would have ruled this, that, or the other way. I've been practicing for long enough to know that that's a good way to get to make a fool out of yourself. But I will say that when you interpret this, when you look at this, these are certainly unique circumstances. This isn't, oh, I forgot. This is the builder actually showing up and saying, here, Ms. Powell, sign this form. I got to take it to the county so I can get the permit. Ms. Powell saying, great, here you go. And then him not following through with that for whatever reason. that's problematic, especially for my clients. So yeah, of course they continue with the building process. They thought they had the permits. And so the building continued and all that work that you've seen. Now, at some point, I believe in March of 23, they were reported by the city to the county for operating a short-term rental without and this timeline is in the PowerPoint as well, for operating a short-term rental without a license, when in fact they weren't, and no follow-up was ever, no enforcement was actually ever taken on this for doing so. But more importantly, the county came out at this point, and at that point, certainly knew that there was an issue with the permits. And yet the county did nothing. They let it set. Now, I'll get to something called estoppel and what that is in a minute. But courts look very skeptically on a county or a government entity that sits there and does nothing. And then comes out and claims later, while they know work is going on. And then comes out and claims later, oh, you know, you couldn't get this permit or the other permit or the other thing. Sorry, I didn't tell you $10,000 ago or $50,000 ago, but now we're gonna stop your project. And the other note I wanna make is you have this huge packet in front of you. And it's noteworthy that things were added by the city and by the county working together to this packet. In fact, highlights were made on our exhibits that we didn't make. I've never seen a city and a county work together and be so eager to fight something like simply running a short-term rental. The prosecutorial nature of what is going on here is truly alarming. The point where you have to wonder what it is about the Powells that the city doesn't want them to run a business in their area. They've already applied a provision that the court determined wasn't in the ordinance and never been used before. And so here we are back again the second time. And now still, we're looking at things being added to the record. We're looking at, the city and the county communicating to try to build this case. And it's a little bewildering as to why they would do that simply with someone who wants to run a short-term rental. It's not yes.
Ask you a question.
Absolutely.
What do you mean when you say the city and the county moving together? What are you referring to?
So in March of 2023, when the city talked about it, and some of that stuff is on there on the PowerPoint, so I would refer you certainly to the timeline that's in there.
Page 40.
It's on page 40 of the PowerPoint.
I have it up.
But essentially, the city reported to the county that there was an unlicensed operation going on. And the city and the county have been essentially communicating with each other for whatever reason and strategizing to try to figure out how to build this case against my clients regarding permits. And there's emails, there's communications between the city and the county, and all that stuff is in there. As to going out and asking for inspections, and then the county, strangely enough, even though they knew something was going on, instead of saying, hey, Mr. and Mrs. Powell, you don't have a permit for that, which they're frankly required by the ordinance to do. And saying that, which if they would have done that, considering the fraud that the contractor did, my clients would have said, wow, that's news to us, let's fix it. And the reason I know they would have done that, because 6 months later, when someone finally made them aware that these permits weren't actually issued, that's what they did. They voluntarily stopped work. They self-reported and said, what do we do? Help us. And that's what started this, this huge back and forth with the county. And it should also be noted that the county, the last letter I received from the county, at least as to the first floor, said, you know what, we understand that it's hard to do this before the ZBA rules. Get back to us a couple weeks after the ZBA, and then we'll deal with it. Meanwhile, it turns out we get this timeline that's added to your packet by the county at the request of the city, setting forth this timeline, which has some serious inaccuracies on it and omissions. So it's problematic. But I'd like to return, if I could, to the issue of permits itself. Because as I said before, simply getting those permits is not strictly required. What is required is getting to that point in the process. And what your job is to determine is, did they get far enough along in the process to make themselves into a vested right?
What, can I ask a question?
One of you, yeah, you both have questions, either way.
When you say, did they get far along in the process to go for permits? What in your client's mind constitutes far enough along that you would go after permits? Even though I know we're not supposed to talk about permits, but you've said this several times, but you don't quantify what is far enough along to get permits.
Sure, so I think you're misunderstanding what I'm saying. They tried to get permits. Before they even started building, they tried to get permits. And so what the courts look at is, did you actually start building? And one of those steps in the process of determining, did you start building, is, did you go and get building permits?
Which you did,
Because-
which they didn't.
Which they didn't, but they tried to do.
Do you think that the construction, the renovations that were occurring were lawful without a actual valid permit?
I think they were lawful because there's a process that we're going through to remedy the actions that took place. Now, if they were just thumb their nose at the county and say, we don't need a permit, forget it, I can see your point. I can see that we may not have, you can make the argument that they weren't lawful. But when they're working with the county, when the county's aware of the problem and is at least representing, kind of stringing you along in this process and representing that there's no issue and that we'll work with you on this, then I think that's certainly lawful. When the
One or more of the cases referred to, as part of the vested right analysis, that the construction has to be lawfully occurring. And I understand, they thought that the contractor had taken care of that. But would you concede that the construction, if they didn't have a valid permit, that the construction was actually technically not lawful?
No, and I won't for this reason. Because it's not a case where they simply ignored the building code. It's a case where they certainly attempted to comply with the building code, and the county had actual knowledge of what was going on. And so when the,
Did they not, did you or your clients or not check on their contractor in terms of, let me see the permits that the city or county issued? Did they do that shortly after they were asked to sign the permit?
my understanding is, did you wanna?
Okay.
My understanding is that they were told by the contractor specifically that those permits were, that everything was on course. And it wasn't for 6 months later that they were informed that there was an issue with permits. So the contractor, I mean, I guess I don't know what duty you're putting on them to micromanage their contractor. But when the contractor says, here, sign this form, I'm gonna go get permits. And then says, I got the, everything's on track. They're not the building experts, the contractor is. So,
I don't know about this, but you tell me. Do you post a tape, nail, tack, a building permit to the structure while the work is going on.
Yes.
Yeah.
I've seen that, I thought.
Yes.
Yes,
Yeah,
you
but
also get a piece of
you
paper
don't-
that
you don't
says,
need to do that if you're doing demolition. You don't need a permit for demolition. And if you are doing demolition, you're doing considerable expense in time and material to do work. And that's not unlawful. And you can even start construction and you don't need to technically have the permit posted until you're calling for your first inspection. And I did construction for 50 years, and when I told somebody I got a permit, I went and got it, but I didn't go show the customer that I had it. I just assumed that they thought I had it. They assumed that I had it. So I feel like they're in a proper position to assume that the contractor got it, because unless they had reason not to think it, why would you ask them? I mean,
and I've done,
and when we had this meeting before, I was the only person who voted contrary to the board, and I didn't say anything the whole meeting because I'm not someone that says a lot. But I felt like right from the very beginning that they were not trying to deceive the city or the county or the zoning board. They thought they were doing everything the right way. And that's what most people who aren't familiar with construction, which I said before, I've done for 50 years. Most people say, geez, I don't know anything about this. Will you do it for me? And then they go happily back downstate or wherever they live and they think things are good. So I kind of feel like maybe for me, the whole thing started at the very beginning when they were told on April, or, back in April 22, the realtor said you could do that there. Sarah Beck said you could do that there. And that's what they went with. And I think it's ironic in this whole packet that there's a great big section here about Mike and Denise Croak's project, which I don't know what that address is, but very similar. And they're very good friends of mine. And I went through this whole thing kind of with them. And I feel that this is such a similar thing. And maybe that this would be so easy for them to fall under the same circumstances that they had.
Thank you, Mr. News. Could we add some
May I add one
texture?
other thing?
Go ahead.
Also, I think it's important to note that because we are a commercially zoned property, it's not the same thing as being a homeowner on a residence. We legally in Emmett County cannot file our own permits. It had to be done by a contractor and or an architect. So on the assurances that we both got from the city, we were operating with complete transparency. We filed the business license, which has later been revealed was to our detriment because that is when this all started to unravel behind our backs.
March was.
In March of 2023, we had taken every steps. The business license I could have filed later on, but I was signaling and making sure it was very clear to everybody what we were doing. I owned a business for almost a decade very successfully in Chicago. We moved here because we were inspired and wanting to come here and travel with our pet. This entire purpose for moving, this was the impetus for doing so. We're both graduates of one of the top 10 universities in the country. I don't understand. We have done everything within our power to work with everybody. We have done it with professionalism and I think grace under incredibly stressful circumstances. And at any point where we realized that they weren't in place, we immediately called the county in for an inspection. And I also want to point out too, when you ask about was the work lawful if the permit wasn't obtained, I do want to point out that when we brought through, I think it was September of 2023, when in July we had parted ways with the contractor and fired him as soon as he admitted he didn't have. And we self-reported to the county that he believed that the work was likely to code and that it would be easy to attain. It would be a very simple process for us to get that. And the only reason that that was halted is because the next step we needed was to hire an architect. We had interviewed people. We had gotten to the point where we had had several iterations of a proposal from an architect and were ready to sign the contract. This is December of 2023 at this point. And the architect backed out because they were so uncomfortable with what was happening with the city and the county. And that also halted the project in totality. There wasn't very much we could do to move in any direction to secure those permits because we couldn't take the step to hire the people we needed to hire.
We could just return to page 40 briefly too. I think putting this in the context of the timeline is very important. So this is March of 2023. The moratorium comes down in July of 2023. We are unaware that we do not have permits through our contractor until,
It's July.
yeah, July of 23. So in March of 23,
Ironically, the
can I
day,
please continue? In March of 23, sorry. In March of 23, zoning administrator Denoyer sends to the Emmett County Building Department a link to our business's website. And it's not just a link to the homepage, it's a link to the property detail section that details the ongoing construction as it's occurring. And has pictures all over it of the construction.
renovation status and planned updates is the section that has been housed there.
Correct. Go back to page 40, please. And Emmett County Building Inspector, Mr. Richardson comes out to our property, with no notice. Frankly, skulks around, ascertains that work without a permit is occurring, enters work without a permit, enforcement B is occurring in March of 23. Says absolutely nothing to us after the fact as well. If we are notified and alerted to the fact that this is occurring, I mean, not only are we protected from the further victimization that is occurring with our contractor, which a substantial amount of work did occur after this moment as well. We aren't having this discussion. We are both with permits and substantial reliance on those permits. In my view, it's the government, in this case, basically acquiescing. It's de facto approval of the work, not taking the step that they are lawfully supposed to take to issue a stop work order. The government is intended to, is designed to protect us in an instance like that, and instead it's been used against us, which is, I mean, that's just a really dangerous standard, in my opinion, to approve. I mean, if, and this is my last point, Joe, sorry. If the board were to say, I'm sorry, we believe it's a bright line rule, you can't advance based solely on this issue of permits, you would basically be saying this that has occurred with the zoning administrator and the county working in coordination behind the scenes, and being, you know, we talk about compliance and lawfulness, not complying and not being lawful with their own work behind the scenes, coordination, whatever you want to say, you'd be putting a stamp of approval on that.
I also
I'm done.
want to say to that point as well, in the document with the timeline that was submitted, I believe, by Mr. Doss from the county, as Mr. Zaya said, there were misrepresentations and omissions, including a visit from our new contractor to county, a 20-minute phone call that I had with Mr. Doss, both in March of 2024. But the most key interesting misrepresentation is how they represent, I guess, the excuse for why county protocol and ordinance was not followed following the March 29th visit in 2023. And the reasoning they gave was that they arrived, they observed no construction happening, and that they observed that a window decal sign was put on the window, which they said previously said Petoskey Electric, now said that the Mittman, which we posted just because we had gotten photos done of the upstairs. It was a branding purpose. And that they simply observed a change of use, that there was nothing having to do with work without a permit. That is why they didn't take the options that they were required by law. But if you look at the system, the enforcement is enforcement B, work without a permit. The link that was sent directly to the county is about renovation status. They were clearly denoting that work was happening without a permit. And also, I do want to mention that our records indicate that not only was the business partner of our contractor present on that date doing work, but so was the drywaller. There would have been trucks outside, and then the other pieces, I have actually a picture of the decal that was put up. You can see me hanging it in February. It's on a double glass paned French door. You could see inside. You could see that there were construction materials everywhere, open walls.
There are also text messages between us and the contractor.
Well, and there was no sign there before.
In which they indicate that the contractors were also present.
Sorry, these are new slides.
We're also present on the 29th. It's very clear that, well, I mean,
It's a misrepresentation.
work without a permit is posted onto the official record, so I don't think there's any mistaking what they knew.
I think as a bow on this, the key here is, and again, to your question, if in fact the law had been followed and the protocol had been followed, we have obviously very clearly from our documentation prior, we were under the impression that we had permits. We wanted to have permits. I am a very by the book person, as if you could tell by the type A nature of this presentation and the amount of documentation that I had. We would have been grateful for the knowledge because it would have saved us thousands of dollars. It would have saved us time, and we would have been eager to correct that right away, just as we were in the summer when we.
Did your contractor victimize and defraud and cost you money?
Yes, and he
Yes.
also.
You sued him?
We were in the process of getting a lawyer to sue him, but unfortunately, this case has had to take precedence, and we are not developers. We're both in our 30s. We were in our mid-30s when we started this project. And we had to responsibly keep enough funds back to finish the project eventually. We've been in this lawsuit now for 1.5 years, going on 2 years, just with a lawyer, and that's not counting, starting the project in 2022. We just don't have the manpower and the funds to do them simultaneously. I do also want to point out that in my interactions with the county, the very first time I interacted with Mr. Doss in March of 2024, he let me know that the contractor was a known entity and is still practicing in Emmett County. He is still defrauding people. He told me to FOIA the county to get evidence of the other people he had defrauded.
Well,
None of these people have been
excuse me,
identified. Sorry.
I'm really sorry, but,
Yes.
and I know you feel we're not your enemy here.
I understand.
And we are trying to, the best of our knowledge, based on a finding of facts, okay? The court has ruled that we have to, our only decision is based on whether you have demonstrated a vested right to this project. Permits are a completely different issue and you're still gonna have to get them. That is not our discussion. Excuse me. I have over 50 years in this business too. Permits are for safety. Permits protect people. It's not our discussion. You've already told us it's not our business to talk about permits, yet we keep talking about permits. Let's talk about the vested. Let's talk about the money spent. Let's just move on because that's the only decision I feel, and Laura, you can tell me different, that we really are making.
Yeah.
Did you spend the money? Not whether you're hurt or whether you were misled or all those other things. It's did you spend the money? That's the only thing the court has given us permission to talk about.
We appreciate that, and actually, I think what you're sensing in me is action. We are only speaking about permits in defense because we feel that that is the defense we had been forced to make to you guys, but we agree that the crux of the argument.
So let's-
Yeah, I'm sorry, I just want to say one thing.
Sure.
Just to clarify. In your memorandum on page 5.
Sure.
Under all of the cases cited herein, a building permit or its counterpart, a permit to commence operations is the sine qua non for obtaining vested rights. So it's both of them, and there is case law which supports that standard.
So, okay, then I stand corrected. So,
That's a reason we can talk about.
That's the reason. we talk about it.
okay.
There's relevance.
Permits are very easy to discover, whether you've gotten them or not. You have to write a check and there's a piece of paper. You are opening a business and to not follow up on something under construction, to me, is more just troubling than the fact that your contractor didn't get it. You didn't follow up on it and you're trying to open up a business.
But we
And
did.
it's, no, you
Hold
didn't.
hold on, let her finish.
I don't have a piece of paper that in this breakdown that shows me that he gave you, that he gave you the piece of paper. You don't show me that. You don't show me the piece of paper that you signed for the permit. You don't show me a check that you wrote to the county.
It isn't.
No, it's,
Firm that she signed.
I see that he said, show, you know, can I come by and you sign the permit? Sign for the
At the
permit.
application,
Yes.
Oh, application for the
right,
permit.
right, yeah, the application.
So if we're gonna talk about permits, the permits are for life safety, number one, to make sure that a building is up to code and follows the standards of codes. And we spend a lot of time researching that, right? Your postcard permits from your subcontractors, they can't pull one until there's a major building permit. So that means your electrical, your plumber, all of those people are also pulling permits. So I just, and I've done work. Never mind how much work I've done. It's a big piece of paper and it has your address on it. And if you drive around town, you can see where everybody's permit is.
Well, I think he has you know, he does not normally he has not normally done that in his line of work.
I mean, I don't know what line of work you're in.
A builder.
I'm a design professional.
I get that, and to be honest, I have had work done and I had no background. And I made sure I had permits and I always had paperwork. But I do have to consider what he says as being a builder, that his clients all relied upon him to tell the truth.
So we
And they never saw it. So I do have to give some credit to that, even though I do agree with you that as a non-professional in any of those fields, when I remodeled, I knew I needed to make sure that we had all those, and I did receive paper. I have received paperwork from every contractor I've ever used when the permits were filed. Do you know what I mean?
I've
But,
never-
you know, I think that there is some.
We always have the permit record in a project file.
Just,
Because we have inspections and the inspectors are gonna come and they're gonna change the drawings and we have a whole permit, there's a whole permit process where they come back and they say, what is this? They want interpretation, they want answers, they don't understand this in such a drawing. So I'm a little surprised that somebody thinks that they, particularly when they're changing use, when they're going from a office, commercial space to a short-term rental or hotel, as the court has called it, that they are not, you know, that they're just not questioning anything.
Jim, are there electrical permits, plumbing permits, general building permits? And are they pulled by the electrician and the plumber?
Yes.
Because subcontractors all pull their own permits, but I don't think I ever in my life had a customer come up and say, can I see your copy of your permit, or can I see your electrician's permit?
What you told us.
So we
But I always,
we fully agree with the level of seriousness that you're talking about permits. We agree with that. I'm a little dismayed that when the county comes out and is aware of this going on, apparently they didn't. The county didn't agree that there was seriousness. They took no action. And so I'm a little dismayed that the sort of the heat, I guess, is being placed on property owners that, again, signed permit forms and were unaware. And then when we did become aware, self-reported, yet well in advance of us self-reporting and becoming aware, the county knew. And not only that, but the person that we contacted from Go to approve, and by the way, Lisa approved this project. The internal email between her and Sarah Beck is the initial approval. She approved it.
she approved a license for a first floor or second floor.
Hold
Can
on.
I say something really,
Sure. We're getting,
I also just want to make one quick point, because again, I think what you guys are mistaking is passion here. We adamantly agree that the permits should have been obtained, and that was our wish, and that was a very explicit discussion that we had given responsibility to our contractor. And I can agree that, with what you're saying about, at some point you should have asked. We did. No one came to us and uncovered the permit thing for us. In July, once the project, the contractor was revealing himself to not be telling the truth, to be saying he'd be working and not be working, we pressed for those permit applications, and then he told us he didn't pull them, and we immediately pulled the plug.
So
Then we
there's,
immediately self-reported.
okay, so there's
So,
no
yes, we-
inspections during construction.
We did get there, perhaps later than you would have hoped, but I don't think that it's fair to.
Ms. Marshall, I think has a question.
So I just have a point, and I think maybe we could all consider it. You have a presentation to make.
Sure.
And although I appreciate the conversation that we're having, I'm afraid that we're not getting to all of what you want to say. And maybe we could go back to that if we all agree, and then save questions. So I think
Okay, thank you.
there's so many loose ends here, and we're muddling them all.
Yes.
And I think it'll be hard to get to a
I
conclusion.
do have to clarify one thing, and then Joe, I'm turning it to you. I swear it will be very brief. If you could turn to page 33 in the packet. So when I say that Lisa approved this project, the emails are from
Sorry,
April
36.
36. The emails here are from April of 2022. Our realtor had sent the message inquiring about the zoning. And then Sarah emails Lisa saying, "Morning, can you tell me if 215 West Mitchell Street would be allowed to be a short-term rental? Thanks, Sarah Beck." Mr. Neuer, the zoning administrator, responds, "The property is zone B3. As you know, anything starting with an R or M is considered residential and does not allow short-term rentals. And anything starting with a B is considered business and does allow short-term rentals." That is the zoning administrator approving our project from go. That is not the zoning administrator approving the project at any later date. That is the zoning administrator
No,
telling,
that's incorrect.
I think she has.
telling
I am not-
Sarah Beck.
I am
Yes,
not a
that's-
city administrator at that point. If you look at my title on the email, I'm an administrative assistant, I'm not a zoning administrator. And that is not approving a project. That is stating that what I have been told up to that point by the city planner zoning administrator is that if it starts with a B, it's allowed. So that's what I was relaying to the city. Or to Sarah
The
Beck.
materials that you referred to, are they in the mountain here?
Yeah. And I'll just say that the court has already said that it's allowed. You know, the city already once said that you can't do it on first floors.
So we're.
We're past that point.
Past that.
We've appealed that to the court, and the court's come back and said that the city was wrong to try to impose that requirement and that they are required. That they are permitted. What you're hearing now, and I'll try, I've been up here for about an hour now, so I'll try to summarize and to try to complete the points I need to make as efficiently as I can. What you're hearing is two people that have been involved in this process for 2 years, at least 2 years. Actually, it's 2025. They started this in 2022. They bought it because they were told that a short-term rental was in whatever capacity that you could turn this into a short-term rental, and that's what they tried to do. The question before you was, did they have a vested right to run that on the first floor? The law says if they did work of substantial character to the property, then they do have that vested right. We have shown here that they have that vested right. Now, I also put in the packet a great deal about estoppel, and I'll be the first to admit that the court did not remand this for consideration with estoppel argument. That being said, it's going to come up either now or when it goes back to the court. And I'll just briefly mention that estoppel is designed for when people are told one thing, or a city and county leads someone along and tells them that things are permitted, or at least allows them to believe they're permitted, and then tries to pull the rug out from under them. I think you've heard a conversation here today that demonstrates that that's the case here. So the point I want to make is that estoppel very much is still a part of this case, whether it's discussed now or gets discussed at the court at a later time. It's certainly going to be discussed at some point. That being said, the point I want to make here tonight, they did work of a substantial character. Permits, no permits, whatever happened with the contractor, whatever happened with the city and the county, and we've put all that in there in great detail. for your consideration. The ultimate question per the case law is, did they do work of substantial character on the first floor? I think the pictures and the invoices and the videos that we've included in our PowerPoint clearly demonstrate that they did that. Therefore, we would ask you to reverse the determination of the zoning administrator that for the short-term rentals were not permitted because they weren't allowed on the first floor, and allow my clients to simply move forward in running their business. That's what they want. That's what they're asking. Yes, sir.
I think it was in your circuit court reply brief that you referenced equal protection and due process and intimated the intent to file a federal lawsuit against the city. Do you believe they have some personal vendetta against the applicants here?
I don't go into motives. I just know what's happened. I know that the city for over a year or 2 years tried to impose a requirement on my clients that the court later said didn't exist, and that they never tried to impose on anybody else. I know that they've gone out of their way to stop these people from getting a short-term rental license when they've gone out of their way to help, as Mr. Nibbs has pointed out, other people in getting a short-term rental license. And all I can do is look at the Powells and say, what is it about them that is different? Why would the city and county do this?
Why?
What is it about them, Steve? What do you think?
Serena?
Well,
Unfortunately, I think Ms. Powell has been treated differently because of her Asian and Hispanic descent. She has been being treated differently at meetings. She's been treated with us. She's
because of
because of
Protecting class.
her race, because she's of Asian and Hispanic descent.
How would we know that?
I didn't.
I didn't know that.
Not one.
No.
Well,
Well, I didn't know that.
So I think that's
I mean-
terribly offensive.
Joseph,
Excuse me?
It's very offensive to tell a person of color that they don't look like what they are.
okay,
Well,
let's.
I think you were bringing
I was
something.
asked a question and I answered the question.
into play, because it's not.
I was asked a question and I answered the question.
Better than white people.
candor, you were
What's that?
straight about it.
Please don't.
All right, but your reply being brief at the
court level
was in November. You have or haven't initiated the litigation on equal protection and due process?
No, we haven't filed that claim yet.
Pardon?
No, we have not filed that lawsuit.
Lastly, I know I'm hogging too many of the questions, but I saw in in your claim of appeal, we had 10 errors that the zoning board of appeal had made. Have you submitted all the material that you believe would help us address all of the cited errors that we made?
Testing my memory as to what was in the claim of appeal. Yes, I believe the record is complete to address those issues. And if you want to ask me more specifically,
That
I'd be
is,
happy to.
either yourself or your clients submitted a FOIA request to the city and apparently revealed things that had not been presented to us.
Right.
And that would be pretty serious significance in your estimation. Are those items that you flushed out through the FOIA request that didn't get to us prior to our decision?
Yeah.
Are those in here?
Yeah,
All of those?
they are.
The communication?
Well, we didn't put the entire FOIA response in there, but yes, the communications were attached to our brief. And the court relied on those communications, apparently found them important in determining that this requirement that they were trying to enforce didn't actually exist.
Madam Chair, could I ask a question?
Oh, yes.
Sorry, I'm here as the city attorney over
I
here.
didn't know where the voice was coming from.
From beyond. I don't know if this is in your material or not, so please help me out if it is. Is there a breakdown of how much of the work on the first floor would require a building permit, regardless of whether there was or wasn't a permit, but work that required a permit versus work that did not require a permit? Like, I presume, appliances don't require a permit. And I don't know if you've done that analysis, and I just am curious if it's in there.
The invoices are in there that detail the work that was done. Do we break it down based on permit and non-permit? No, because they thought they had the permit. I mean, they got the permit, then they started work. So they didn't break it down on that level as to what did and what did not require a permit. But the invoices are there, which detail, the work that was done. So those can be referenced, certainly. And, the pictures also demonstrate some of the work that was done.
Thank you.
This will be my last. I thought that I saw in maybe the city's communication to us, that some of the, city staff in the agenda memo, city staff notes that the floor plans provided in Exhibit 5 do not meet the ZBA's request for prior floor plans. Right. What's your response?
Well, we did the best we could. We were asked to provide prior floor plans. I think on the first page we went over, I think it was page 20, we showed you kind of a before and after floor plan. What was there, what we're going to turn it into. But we did our best to try to respond to all those documents, and we didn't have, not owning the building at that time, we didn't have floor plans of what it was before. So we tried to provide what we could, and we noticed that in the 2020 or whatever it was, somebody went to the planning commission and attempted to, I think it was open a medical marijuana plant or something. I think it was a potential buyer trying to do that. Our thought was those documents would have some evidence with floor plan, would have some evidence of what the building was like before my clients got in there. That's not something I would have typically submitted to you, but the board specifically asked for prior floor plans. And that was our attempt to try to do the best we could to provide that. That was the purpose in providing those.
So you, sir, said that you are finished with your presentation.
Unless the board has any further questions.
I have one question.
Sure.
So a letter from you, January 30th, 2025 to the county.
Okay.
And it's the ongoing question about permits. And you say, well, I understand that permits will be required regardless of the outcome of the zoning dispute. One of the items you requested and that is required to move forward is architectural plans. John and Mallory have consulted with an architect, but unfortunately it is difficult to say how the project will be completed until we know what is permitted. So are you looking, how do I interpret that? Are you looking at other possible uses for the building?
No, I can answer that question.
Okay.
So as I said, when we self-reported to the county, and had someone in September, the step that they gave us to make the first floor permitted was we first had to start with an architect. I actually suspect that that is why our builder ultimately didn't attain that architect, is because he hadn't discussed that we would need to pay for plans because it was a commercial space. Regardless, we immediately took that, again, the permits were important to us. We immediately took that direction and began meeting with people. We were well underway with meeting with Elaine Kaiser to the point where we were waiting on a contract. When it was December at that time of 2023 and the law was coming to fruition, it became apparent that there was some dispute over what the zoning would be. And we were also trying to ascertain at the time if we had a workaround where we could instead say we were a motel instead of a short-term rental, as a fallback if in fact the short-term rental piece didn't work out for us. And Elaine pointed out that the uses are different. One is residential, one is commercial, and therefore the code book that you fall under and where the permits would be pulled would be different. So in fact, when this entire dispute unraveled, it was partially because she didn't want to be embroiled in this issue, but also because she said you're a long way away from being able to start anywhere with an architect because you don't know the outcome of the zoning dispute. So for that reason, the project has been on hold since that time. We haven't done any rentals, even though the second floor is licensed, because we are responsible and it is a safety issue and we do take that very seriously. So we have done the very best we could do within the complexity and the intertwinedness of this to remain compliant to our own detriment. It has been financially very hard. This is my primary source of income. For 3 years now, this has been the case. So we unfortunately will have to reinitiate that process after the result of the zoning dispute indicates what our next best step will be. No, we have never entertained any other use. It would be under the guise of going probably then as a motel. The reason that we haven't done that as of yet is because the fire suppression that is required in order to be a motel versus being a short-term rental is the hundreds of thousands of dollars.
If I could add just one clarifying fact too, so I keep returning to, in March, the county comes out, says nothing. In July, we schedule self-report and schedule an inspection. And a inspector comes out and tells us everything won't be a problem. And in February of 2024, well, conveniently for the county comes and says, we want to open the file at this juncture, which of course is after the ordinance has changed, and obviously should have occurred in March of 23, the day the work was identified.
Does that-
I'm sorry, to clarify what Mallory said, if I might.
Yeah.
You said you haven't rented the second floor.
We haven't rented anything.
Okay. Do you have an occupancy permit for the second floor?
We are on complete pause because
So you are permitted, you haven't met the requirements to open the second floor.
the second floor, so or should we even get it? I don't think
Well-
that this is even relevant.
Well, she asked a question, so we can answer the question. She has liberty to ask
Okay.
what she was curious to,
So-
that's fine. I believe that we went through the permitting process and we do have a short-term rental license for the second floor. And to my knowledge, you do have an occupancy permit for the second floor.
So
This, I don't know.
when we met with Mr. Daw, and I think this is in his timeline too, this is why I was trying to stay focused on the first floor. They have, since 2025, tried to say that work was done without a permit by the previous owners
Right.
in the second floor. When this wasn't brought to our attention in February when he came to visit us, though his timeline says that he did tell me at that date, he did not. I actually called him on the 8th when we received the violation because I was surprised by the violation, and the violation was very unspecific. It made it seem like he believed we had done work to the second floor. So I called and had a 20-minute conversation on the 8th of March with Tom Doss with regard to the second floor because we weren't aware that an occupancy permit was needed because it was already a resident upstairs. There was no change of use for the upstairs. The upstairs was already an existing residence. And we were told at the time that he believed that the issues were very minor. They were likely already to code. It was actually the property was owned by an electrician, Petoskey Electric, prior to our ownership. And that while we could take steps to secure the stuff with the upstairs, that it was by no means urgent. The property isn't inhabited. We weren't renting it. And obviously, though they are separate floors and separate uses, it is one singular property. And you have to understand at this point, we don't have a contractor that has done any work to the building. I promise. We had done work to the first floor with a previous contractor that we had fired. And had someone who had, as a favor to us, was going to step in as a contractor, but hadn't done any work yet.
So that's,
And then on the second floor, we didn't even know that there was work.
so that's Matt person?
Matt Groff, correct,
He's the second person.
I'd
correct.
just like to clarify, because I didn't say it earlier too, the building permits were submitted by him. Sorry, the file is created
getting
with the
to that.
county.
So we submitted an application for both the first and second floor. At that time, our contractor actually went in on March 11th, though not on Mr. Doss's timeline, and spoke to Marty Van Berlo, who is the head of the department. He is the boss, the building official. who said that he was going to combine those two applications into one singular permit. That was reflected in the system. The second floor violation was actually marked as canceled. And the system was updated to say, per Marty Van Berlo, these are now combined, everything will proceed under one permit.
Yes.
We were up to date on all of that. And then all of a sudden in January of this year, they came back to us basically saying that that wasn't the case. And I will mention that the system has been changed. I have a screenshot from March 19th of 2024, and the system now says something different.
Completely done after this, I promise, but to return to Mr. Nibb's point about the Croaks and 120 East Lake Street. 120 East Lake Street is not in here giving a 2-hour presentation. 120 East Lake Street is not being interrogated. 120 East Lake Street was willfully grandfathered by the city and does not even have the requisite zoning to be a short-term rental.
Didn't previously either.
Question was, do we have an occupancy rep for the second floor? Yes, because one wasn't required because there's no change. It's always been residential. And we're licensed for a short-term rental on the second floor, which we haven't started yet because we want to run it as one business, but we are licensed on the second floor. The building department has contacted us because they think that work was done under a prior owner.
Right, I know.
And we've had back and forth to try to determine what in the world they're talking about. And we're still in that process. But that's the second floor. It's not something we're trying to establish here.
And I will also point out that the evidence that he submitted about the second floor in this packet, we had asked for and has never been provided to us, was provided to you first.
You just lost me. The evidence about the second.
So he provided, I believe, the first time we saw what looked like a YouTube video to like a 2012 listing for the property, which we had never seen.
Oh.
And we had asked for documentary evidence so that, because we didn't do the work. So we wanted to make sure that our contractor, who also didn't do the work, knew what to put on the permit application, which is a requisite thing that we have to do in order to file that application. So I called Tom Doss to say, hey, we're happy to do this. I'm really confused because I wasn't aware that there were any issue. We have the disclosure that says they didn't do anything. And I need to know what it is. And he couldn't tell me on the phone what it was. What he narrowed it down to was that he really thought it was only a railing on the staircase. And he couldn't point me to where any of that evidence was. So again, when this came up in January, when we believed the entire thing was on hold on one permit, it came up in January, we again asked, you've not given us any evidence of what this is. You can't detail what the issues are. It makes it very hard for us to move forward absent that information. We've asked for it, I think, in several letters now that are in there. It is striking that none of that was ever provided to us, but was provided to you.
Yeah, the letters,
The pictures.
oh, the pictures, okay. Okay.
Is there any further questions?
Is there anything that you, Mr. and Mrs. Powell, want to say?
I'll say one thing. I remain hardened and hopeful despite the tone of where I think some of this has gone. Sorry, really trouble. I cannot explain to you the duress that this has brought on us, the strain that this has put on us. And just as an anecdote, if I'm not sure if any of you have perused our website or read our mission statement or read the letter from us on this, the entirety of us moving here and starting this business was about our mental health. We moved here so that we could have a business that we were proud of, in a place that we vacationed, that we dreamed of, where we could bring our pet, to bring what we had loved so much about this space to everybody here. And I don't want anyone to think that the passion with which we are trying to present what it is admittedly a very convoluted and very complex subject at this point has any vendetta or any direction at anyone specifically. I think what you are sensing is just the weight that this has put on us and the frustration that it has put on us, because essentially the court has already ruled that for 2 years, we were literally told something that was black and white in the law that we were assured before we purchased wasn't the case. So when you speak to a bunch of people that tell you up is down all the time, and you operate with transparency only to find that people really aren't telling you things that are, as a taxpayer, part of their job to protect you as a service, I think it is a natural outcome of that we are emotional and defensive. So I just want to make sure that you guys understand that is not, that is what you are hearing, and that our intention has always been to work collaboratively with the city and the county. Our intention is to do that moving forward if we feel that a space is made for us to be able to do so. And I ironically think that if we had been allowed to move forward, and if we are allowed to move forward, you will see that this is really a gap that existed here in Petoskey, and we would be your star students. Mistakes were certainly made, to Ms. Stein's point, with regard to the permits. We're human, we're learning. This was the first project of this size we had put down. It is pretty clear that our impressions were that we had permits, and the second that we knew that we didn't, we took the steps to make it right. And our ask has always just been to allow us the space in order to move the project forward, which unfortunately, because of the nature of the building, has been completely stalled. And the only way for us to remain compliant with the city and with the county and to be responsible to our guests has been to just not do anything. And I just want to make sure that that intention is clear.
We do appreciate the quality of the discussion today and have seen that, particularly with the new attorney, that the board is very sincerely wanting to get things right, and we're hoping that's applied to her case as well, and appreciate your time.
Well, I would like to add too, I think, I was one of the people at the hearing a year ago who, with my Jesuit education, replied ethically, like, you mean you think you can do this just because you want to, rather than looking at case law or the demands of the project. And really, as I have reviewed copious amounts of material, I think the board is obliged to fact find. So the determination of whether or not you have a vested right has to be based on fact. And that's what our obligation will be, to have a discussion and see where we are. And again, it's not personal. It's, those are the considerations I think we have to.
Sure.
And I'm sorry you personally feel disregarded. So if it's any consolation, I'm 13% African, but you probably wouldn't know.
I also actually recently learned from my uncle passed away that I also am a 11%
Right.
as well.
Whatever. You're not alone. It's my only.
Yeah.
Okay, and I mean, but, yeah. Okay, so if there's nothing else, could we take a short break? So I could use the lavatory, and we'll come back to have a discussion. Is that all right?
Yeah.
Yeah.
Is there anything here? It's in-
Just to let them know.
I have a setting in my hearing aids that I can put for voice clarity. I always forget to do it.
Does that make a difference? I went to, the new, brew pub on, the new beer place with Mary Clay,
Oh,
who has hearing aids. I couldn't hear a
I
thing,
know.
and she's like dialing it down
I don't.
and has no problem because she can hear everything, and I'm going, we gotta leave, I can't hear anything. And now going to restaurants, I mean, we went into one the other day. Yeah, we went to one the other day. I went with my brother, and who wears hearing aids, and we walked in and he said, we can't sit here.
Right.
And I did that with, it's constant, the noise
Well,
is constant.
this might have a thing called restaurant mode, and what it does, it shuts off everything that's back there, so I
Yeah.
can hear what's out here. And then it has all around, so I could hear. you know, which usually you don't really need that, because you don't normally want to hear it, it's back there.
Or you might.
Yeah. What'd you say?
Wife might appreciate that feature though.
Welcome, Pat.
I'm having so much fun.
Well, the pedestal to all of this was because of Rose Street. That finding of facts were not presented in the facts that were presented.
Well, yeah, see,
enough.
that's why I'm happy.
And so, you know, we're trying to be more conscious of the facts that we are presenting.
Have we begun discussion with that?
No,
They're talking about.
we are welcoming Pat.
Oh, yeah, yes. Oh, my goodness gracious. Laura has disappeared.
I just paused the recording because I figured there's no point in recording.
I'm
Our
here.
Pat,
Yeah.
Where's my little notepad? Oh, here we go. Ah, goodness. Are we back? Oh, wow, okay.
We're just watching you.
So let's continue. Okay, if I can just maybe try to frame this a little bit. So the first thing we're asked to consider is whether or not the work of substantial character has been done. Let's just review. Heath, did you mention Mr. Dias Heath in your, I think you did.
Yeah, that's the.
It's kind of a standard there.
Yeah, it's also in my brief.
Yeah, so. If. I did download it, because I have a relative who's a lawyer, so I just see the whole thing.
Hey, if I could comment just for a second.
Sure.
We, at least I have not been able to review all the material.
Right.
That is, because our decision-making has to be very detailed, fact-specific, facts justifying our decision. I might suggest that we hold a, we're already an hour and a half into this one, a second specific ZBA meeting to lay out, discuss, and come up with our decision at a second meeting or at the July meeting, and as had been suggested actually in the meeting memo. But that's where I'm at, not being comfortable discussing the issue without reviewing a little bit more of the materials.
Does anybody else feel that way?
I do.
Well, we just got this Friday and there's a lot here.
Right.
And I think to make them wait for a whole nother month, maybe we could do a special meeting in between now and the next meeting.
I'm just curious with the fact that we basically have to decide if they have, what is it, the vested in interest. I mean, how much, there's a lot here, but how much of this is relevant to the vested interest that we have not already reviewed and was not already shown in the presentation? Because I think how much for vested interest, you know, we keep talking about permanents, how pertinent are permits to vested interest? Or is it mainly on the financial amount that they have put into it? So, I mean, do we have enough information now to discuss if they have a vested interest?
And I think to your point, there's 2 points here. One is the permit and the other is how much money and time and attention was
Right,
put
and how
into it.
pertinent is the permit to that vested interest?
And if that has to be determined, then if the permit issue has to be determined, then it seems to me this is a moot point. It's clear, I mean, there's plenty of documentation, whether it's clear or not.
Well, maybe our attorney, can you help define that vested interest and how valuable the permit is in calculating that?
Yeah, I mean, I think that's the $64,000 question, right? And if that had been an easy open and shut answer, I suspect the, circuit court could have held that. I'm not sure that there is, a case that's factually exactly the same, where, you've got an allegation of fraudulent misrepresentation by a contractor. I'm still not sure if the contractor said he did get permits and didn't get them, or just didn't advise one way or the other. But regardless, I also don't think, there's a question that in, the body of case law, there is this link between a building permit and the substantial work, because you don't do substantial work without the required permits. And if you do, it's not, really lawful work. So that's where I think it is relevant to that inquiry. I say that not to, dictate your outcome here. I think if the ZBA wanted, a legal opinion to help with just that part of it, that's something that we would likely have to do at a special meeting in closed session, frankly, because a legal opinion is privileged. But that's where I see it fitting into the remand direction, which is to say, how do you have substantial work, or how do you have work that meets that requirement under the case law if it's work that's never been approved to be done?
From reading, the cases that were summarized here, as well as the Heath Township, they are not completely separate, distinct. There's a relationship, but it's not tightly defined in these cases. But from one attorney to another, you aren't going to have the substantial work with without the foundation of a permit. But it doesn't mean that the permit is only one of the several factors.
Well, right, like Jim had said, there's a substantial amount of work you can do prior to getting a permit, as well as demolition and other substantially costly
You can
things.
file for a demo permit, and you can do demo without the demo permit being issued.
Well,
But
I
you
think, sorry to interrupt.
file for a demo permit.
I don't think the Powell's counsel, Mr. Zayas, would disagree, because I think he said the same thing. Preparatory work, all the case law agrees that's not enough. If you're in that, again, on that line of, is it something you need a building permit for? If you're doing the stuff that's just preparatory and doesn't need a building permit, that's not going to meet the standard that you need to meet for work of a substantial character. I think we're in agreement that the work has to be on the other side of the line, where it has to be work that requires a building permit. The question is, can you give them the benefit of having done substantial work that requires a building permit if there wasn't a building permit?
And we also require a building permit as a second we talked about this as a second level of approval to this, to
No,
what the court has asked us to do.
not really, right? Because we don't issue those permits. That's the county. And this is just on appeal to the ZBA from the zoning administrator's decision. We are not, the ZBA is not, approving a project per se. It's hearing an appeal from a decision of the zoning administrator. So we
So I
can't
guess-
add on conditions. We can only say, uphold or reverse.
So I guess getting back to Bill's question or suggestion that we defer this for a time. And I would say I would not defer it for a year because that would be really a disservice.
Do you mean a
Um,
month? Or you said a month? Certainly not a year.
Breathe.
It's already been a year.
I think a month would be unfair to them. I understand, I mean, I will tell you, I have been up at 3 o'clock in the morning going through this stuff because I'm not an attorney, and so you try to understand the law. And it's a great challenge and very interesting, so, but I don't know if everyone feels that they've had the amount of time to do that work so that you're comfortable addressing what I think are the two main issues, which are, was the work of a substantial character? And the other component, the emphasis or necessity of a building permit, and does the law require that? So I guess we should take a vote.
Is that our, can we answer that question?
Well, we can certainly discuss it I mean, there's case law that Laura cited, you know,
Well,
there's.
I mean, in my experience, is that in 50 years worth of experience, this work required a permit.
Okay, well, we're not
So,
we're not going
but
there
I
yet.
thought that's what you just said. Does this require, is this work required by a permit?
Okay, do we need to determine whether this substantial work was done by a certain time? Because clearly by now it has been done.
Yes.
But when is the time that we're supposed to determine it?
December
Prior to
18th.
the moratorium.
Yeah.
December
That one is
December 18th of 2023.
December 18th of 2020.
And construction began November of 22.
Yeah, and it ended actually the day after the moratorium was passed, was the day we fired our contractor.
And that date was,
July, it's like July 23rd, I want to,
July 12th.
somewhere in July.
28,
23.
23.
So all the work happened before the moratorium.
so the work
We're
happened
assessing the
between
prior.
November and,
And well, he hadn't really done anything in July, so really November and June. So every bit of investment, every bit of work happened before there was even a moratorium against
okay, so that's
STRs.
between
July,
July.
November 22 and July 23, June, July 23.
I think we're the lefties again. On this side of the
Oh, yeah.
table. All four of us.
Okay, so
Really has
again, the
not
question
really-
is, how do you, board members want to proceed? I know Bill has suggested delaying it for a week. Jessica,
I'm fine not, but if
okay,
enough people want to or
Okay, so
feel the need to,
you
I
comfortable?
feel like we've gone over this a lot.
So
Jim?
we will probably need some real work. Preparing our decision,
Yes,
and that
Yeah.
may involve council. And assessing the quantity and not quality, but quantity and cost of the work in this particular window of time.
right.
I don't know if any of you have the precise dollar figure for how much was expended on the first floor in that window of time, but we've got to determine that.
Well, it's, you presented some, they presented invoices and a spreadsheet that broke down the work. It's not clear exactly what work was done in those invoices, and they're all, the costs are all redacted, so, or blacked out. So it's, and also I find the invoices confusing because there's credit. So,
We'll have
but if you look, can I talk about this or?
Well, I think let's decide if what we're gonna do. That'd be my choice. Let's make a decision.
Versions are in the file.
I'm sorry,
The non-redacted versions, I believe, are in the exhibits to this packet.
in this pack.
Yeah, they're in the exhibits of the portion.
Thank you. Let's decide if we're gonna take time to review this, review any questions about building permits, standards. Do it now, or do you want to come back in a week and have a special? So Jessica's neutral.
Yeah.
Bill would like some time. Pat?
I guess I would like some time to look back and figure out for this specific time frame because I did feel like I had gone through this pretty well. But I don't feel comfortable that I know exactly what was done in this specific time frame and how that.
Okay.
My question goes back to whether or not we consider lawful work because of the lack of permit. I understand the work that's been done, so I don't need that review.
That would
But
be
the
a
other-
topic of conversation.
That would be a topic
at our
of
meetings.
conversation.
Yeah,
So do you want to have it tonight or are you willing to wait another week?
yeah, I'm open.
Jim?
I would be agreeable to another week.
Okay. I think a week is a good idea. There's a lot of information here. And I think, Laura, if I understand correctly, you're available to help us craft, if we have questions about how to frame, once we determine things, just the language.
Correct. So I think what I'll do, and first let me ask a question. Does the zoning board of appeals want?
There's a baby in your picture. In your
Oh my
screen.
gosh, it's not real. I'm so sorry. It's my doll, it's my daughter's doll. And I moved it so the puppy wouldn't eat it. So that's embarrassing. It is a doll. When I did have babies, I did not lay.
That's always in my Zoom meeting, so.
That's a new one for my resume. Okay. Does the zoning board of appeals want a legal opinion in closed session at the special meeting?
Yes.
Yes.
So do we need to make a motion to do that?
No, I can just take the direction and it'll be in the notice that I work with Lisa to prepare. The second part of that, and I'll be fully transparent, I would say I would prepare several different, form resolutions that we can fill in. So, whatever different decisions that the ZBA could reach, we'll have kind of a skeleton of those documents so that as you have your discussion in open session and your deliberation and talk about the facts, yes, we can fill those in as we go.
Would the closed session, the purpose of it be to ask you a legal opinion on different aspects?
On the impact of the permit issue, and it would be a written legal opinion that I would prepare between now and then and talk about in closed session.
Okay. Is that something that sounds like a good idea?
I think that's a good idea. I do have one problem. I am not gonna be here next week
When are you gonna be back?
on Saturday, the 14th. I fly to Chicago on Sunday for a week.
Is everybody else available next week?
Yes,
So are we talking next?
next Tuesday.
I would say next Tuesday.
Well, not
Probably,
Wednesday, but
whatever
Tuesday, I'm
the
okay.
calendar-
We have good.
Do we
Yeah.
want to a day or so that she can participate?
Moving, when do you leave?
I leave Sunday and fly back the following Saturday. So it would have to be 2 weeks.
I don't think that with still due consideration for trying to resolve this reasonably soon. Involvement by the full board would be beneficial. And a extra week, from what I'm hearing, is not gonna, excuse the phraseology, but I don't think it's gonna crush the applicant if we make such a momentous decision not in 1 week, but in 2.
Do you agree with his statement?
That's fine.
Okay, you're not, you're cool with it. And Mallory's not sure.
I want you obviously to take the time that you guys need to make the decision that you're comfortable with, or we wouldn't be here on remand to begin with.
Okay.
It is, however, frustrating that it has been a year. We applied actually to originally be in the March CBA of last year, and also that this decision came down in April. And it's now June. That is frustrating. But of course, we want the board to do what the board feels it needs to do to make a decision. We don't feel capable of doing that today.
Quality decision, and we want to really give that to you.
Sure. In fairness, I don't think if you went to Judge Deegan's court with 900 pages, she would be making a decision that day.
No, that's,
You know,
that's really good.
it's a lot of information.
No, we can appreciate.
Okay, you're all right. You're all right. Okay. So how does 2 weeks work for you?
The 17th, I'm tentatively scheduled to be at another meeting, so I don't know if another day that week. I know city council meets the 16th, but the 18th would be a possibility if you are free then, or yeah, really the 18th.
Planning commission is the 18th.
Oh, I can get out. I can have somebody else attend my other my Tuesday, the 17th meeting, I think. So if the 17th is the day, then I will make that work.
Okay, thank you.
Yeah.
Thank you all for flexibility. Appreciate it.
6 p.m. again?
Say again.
Would that also be 6 p.m.?
I think this is a closed session though.
Well, no, it's all one meeting. It's all one meeting. So the closed session is an agenda item. It's all in the same meeting. So we'd have the meeting at 6, call it to order, do public comment, whatever, do a closed session, and then continue the business in open session.
All of our discussion about those.
Correct.
Got
Exactly. All there is in closed session is hearing a legal opinion and asking specific questions about it. It is not for deliberation or discussion or decision making.
Hey, Laura, I thought that it would be very good if, as you had described, you would formulate
Mhm.
several.
options.
Yeah.
Okay.
We don't need a motion, we just need directions.
Correct.
We need a-
I think your consensus is sufficient. Well, actually, since it's a public hearing with the court, and you could do a motion to postpone it to June 17th, 2025 at a special meeting, but you don't need to explain the legal opinion and the multiple resolutions in your motion.
Would somebody like to make that motion?
I move that we have a second session to further consider this after additional review on June 17th.
Support. It's been moved and supported to have a special meeting. No, Pat.
Oh, Pat, I'm sorry, I couldn't figure out who. I just want to make sure I got a second, sorry.
All in favor?
Aye.
Aye. You said aye?
I did.
Okay, all right, there we are.
Thank you.
Thank you.
For your patience. Right, we actually have other.
We do. We're moving right along.
Okay, and I have to find it now because I lost everything.
I put tabs on all mine. I was like,
I only.
where's these other decisions?
I
Pass
passed
it down.
You sure?
I'll give it to you.
Yeah,
that's, I can see.
Okay, thank you.
My only regret is that I thought I could walk out of here.
I know, I was thinking the same thing. I wouldn't have to carry it back home.
Okay, so flipping over, oh my God.
Took mine out.
That's probably smart. Is it at the back?
It is.
it is. It's like the,
Okay, oh, there it is. Okay.
So are you okay with me doing an introduction while everybody?
Yes,
Searches?
so this is the new business, ordinance interpretation of Article 17, Section 1704 regarding parking requirements for eating and drinking establishments.
So, a recent review of the parking requirements, under the business commercial portion of the, zoning ordinance, I noticed that majority of the parking requirements are either based on the number of employees and an exam room or, it's based on employees and either exam rooms or, I'm trying to look in here, sorry.
Square footage.
Square footage, that's the other one, sorry, thank you. There are 2 items in this list that do not have those requirements. One is a drive-through business, however, that is in addition to the requirement of the use. And the other one is eating and drinking establishments. With that being said, the eating and drinking establishment requires 2 seats or 2 parking spaces for every 5 seats. And I did give an example in the agenda memo, if you were to have like the, standalone barista coffee pop-up situation, and they only had a drive-through, they would only be allowed to have drive-through parking. There's no requirement for parking for the business itself. So where would employees park? And right now, our ordinance states that the minimum parking requirement is also the maximum parking requirement. So they would not be allowed to have any parking. So where do your employees park? So this is problematic, or potentially could be. And so I just kind of wanted to bring it to the board and kind of get your opinion. I'm wondering if maybe this wasn't an omission and error, where it may have actually required parking for the number of employees plus the seats. Mortuary is the other one that is listed, that is one per employee of the largest shift plus one space for 4 seats of legal capacity. So that was just kind of my take on what may have been there. We've seen this before in our ordinance, unfortunately, where things kind of fall off the page. I'm not really sure how or why. But I'm asking the board to, I guess, review that chart. I did try to color code it and make it, a little more clear. This isn't something you guys do regularly, in hopes that we can try and maybe figure out what the board's belief that the interpretation of this should be versus what maybe is stated on paper.
The one question I have is, being a downtown business person, our employees have to park where they can.
Downtown's parking exempt, so
Downtown.
they don't qualify. This is just business commercial, so this could be in any district that allows business or commercial uses. So this could be the B3, B3A, B3B, which is our main corridors through town.
Well, I guess what I mean is, if downtown doesn't require parking provided, because you can park on residential streets,
Yep.
why would you have it be different for other districts when they could park on residential streets?
So it wouldn't be different in the sense that the downtown, the B2 is exempt, so that wouldn't apply to them, even as it is here. They're not required to have parking, but when you get into, for example, I guess let's just say that like the urgent care where that is located, let's say something like this wanted to go in there. I mean, they couldn't go in there because there's parking and they're not required to have parking. I mean, but the other thing is you don't want to push them onto residential streets. They're required to have on-site parking for that reason, because there are areas like, I say urgent care for the instance that there's a school right behind them. And if you've ever been by there at 3 o'clock on any school day, people are parked on Charlevoix Avenue waiting to pick up their kids. So I mean, to then expect a business to then put their parking on the street, plus that's also a requirement that has to be approved by the planning commission, and they are limited to, I believe, 20% of the required parking.
So how are we supposed to impact this?
So my question to you is, when you read through these requirements, when it requires like mortuary says that you're required 1 per employee plus 1 per 4 seats. That's the only one that really aligns with the eating and drinking establishment. The eating and drinking establishment only has 2 for every 5 seats. So if you have no seats, you have no parking. So that's where my question is, does the board believe that that may have been an omission and that it should actually be?
Has the planning commission looked at this?
They have not. I come to you guys for interpretation on the ordinance, not the planning
Because we
commission.
can't do anything about it anyway. Yeah.
Yes, you can provide me with your interpretation
So
of
what
what
we
you
think.
believe it's supposed to be, correct?
Well, what happened with Panera?
So they have multiple uses in there, so there was only based on seating. The rest of the parking was from the other uses that are going in that location. Had it just been Panera, it would have only been based on their seating, not on anything
And
else.
you said something about minimum and maximum?
Yes, the minimum parking requirement is also the maximum parking requirement. So when you read this and it says that, like medical office, non-urgent care says 4 per 1,000 square feet of gross floor area. You take this gross floor area, and for every 1,000 feet, they have to have 4 parking spaces. They can't have any more than that, and they can't have any less than that.
That
That's what
sounds
they
like the
have.
maximum is the
Right. I
problem,
think
not
you
the
just have to
minimum.
remove and maximal.
Yeah.
Well, that's for all parking, so that's, I mean, it's not a matter of changing it here. It's a matter of whether or not I'm asking the board, in looking at this, do you believe that there may have been an omission, or do you feel that the intent for the seating would have included employees as well, not just seating?
Does not include employees.
I don't think they probably did either, including employees.
Okay.
Yeah.
Cause like Kate says, all the people that work downtown park down there by the softball field.
Yeah.
Well,
That's
Right, but
Yeah.
that's a parking
All
exemption.
people that are.
and didn't we just go through this with, Kierwins
Yeah.
in their parking lot,
I'm just asking for.
which was supposedly all for
interpretation of-
employees?
Yeah, I'm just talking about the interpretation of the ordinance and whether or not the board feels that that is the correct 2 for every 5 seats. So if you had a pop-up, I'm just saying, is that what the intent is? That there would be no parking and you just get your stacking and there'd be nowhere for employees to park, or was the intent that there should be something for employees based on a comparison to mortuary? I'm asking for the board's interpretation on this, just because to me that
So,
seems problematic.
like, if you're using a coffee shop as an example, all you've got is one person who can probably park almost anywhere.
They wouldn't be allowed any parking on site, so if
Right,
it were a new
but-
development.
So you park, that's what I'm saying, if you only got one person and they park a half a block away, I guess I don't feel like this is a problem.
As an employee.
Yes.
You think you only have one person at?
Well, in those little pop-up coffee
Pop-up
shops that
coffee
you
shop,
drive
yeah.
through, yeah.
You have a small
So
establishment.
I'm not, I can't think of other drive-throughs that would be like, are there any drive-throughs that would require a lot of?
Well, it doesn't even have,
employees?
it would be. I don't know, what I'm being told, Panera said that I was told they were looking to hire 40 people. Now, mind you, they're
40
part-time staff,
people?
40 people.
Well, that's
How
because,
many per shift?
that's because in restaurant business,
It's-
having run one for 17 years, you have a lot of people coming and going and a lot of part-timers and a lot of, and there's only gonna be so many people there at any one time.
So if
40
you did-
employees
So if
means
you had 6
nothing.
employees, where do they
Yeah.
park?
But Panera,
But they
yeah,
can't, that's the issue. I
right.
guess that's why I'm asking for the board's.
Well, it
interpretation.
seems to me the issue is, are we requiring parking for employees at
Do
a
you believe, that-
eating and drinking
do you
establishment?
believe the intent of the ordinance is to include employees as well
No,
as seating?
I
or
don't
just
think
seating?
this ordinance includes employees.
Okay.
You think yes?
I think yes, if the employees need a place or.
Well, we don't think of, again, downtown, there have been arguments about this question. We say the employees don't need to park next to your business
Correct.
because you want to have the space for customers. So walk 3 blocks or walk 2 blocks or walk whatever. So I don't know why this
These
is.
are drive-throughs.
Well,
No, I don't know if drive-through has anything to.
That's just the example I used was.
Lodging is not drive-through, office,
I'm not talking about all of those, Kate. I'm just saying this one in particular.
just this.
Just this one in particular, do you think that the intent was just to have it based on seating, or do you think the intent was to have it on seating and employees for parking? These are just breaking out what is listed here, so
If I
there's,
read that, the way it's worded right there, I would say it was just for the customers, because on other categories up here, it mentions employees. Down
Right.
here, it does not.
that's what I'm wondering is,
Right.
do you think that may have been an omission, or do you think that was the intent?
I think it was the intent.
I don't get it, yeah. I think-
Mhm.
Hey, Lisa, if the voice from beyond here can chime in.
Thank you.
Are we doing this as a formal binding interpretation or? Because, generally for an interpretation, you'd have a public hearing and newspaper publication.
So I guess no, not formal then.
So your answer is no. So the zoning enabling act for an interpretation requires a newspaper notice of a public hearing.
Okay.
And with this, you're working with the planning commission, will this come up in the planning commission?
In the new ordinance, yes, I believe they are looking at.
So as a casual, I don't know what the word is, as a soft interpretation. We can make a soft interpretation that doesn't require a public hearing, Laura, correct? And then
I
it
mean,
goes to the.
There's nothing in the law that talks about a soft interpretation. What I would gather is you're having a conversation right now at a public meeting, which is
Conversation.
perfectly
We're just,
lawful.
we're just talking.
You can talk about anything you want. And if there were, if there were truly an interpretation as the law contemplates that under the Zoning Enabling Act, that kind of interpretation is binding, right? And that's why there are certain notice requirements for it. So the staff, the city would be bound to your interpretation.
Okay.
But Lisa, aren't you talking about your, if you're called upon?
Yeah,
And, oh, it's analogous to this, so this is how I'm gonna advise you. So it's how you employ your interpretation.
That
With
was
some
my- that was
assistance
my-
from us.
That was my ask, but I get the feeling from what Laura's saying that can't be done without
yeah.
actually.
For it to really have any teeth or be meaningful, it would.
No,
need-
you
caught it and
I was given misdirection on how to proceed, so I apologize.
no, you caught it and it should be brought up.
Not by Laura. This was.
Well, and yes, and frankly, we spent a lot more of our time preparing for a different agenda item, so we didn't specifically
Sure.
discuss
No,
that.
yeah, it wasn't by you by any means.
No.
That's fine. Okay,
We're all in this point right now where we're asking and questioning
Yes,
a lot
everything, yeah.
of things, so
Mhm.
I think it was,
okay, well,
Maybe
there's
you
food
caught
for
it.
thought for maybe a future discussion.
oh, good. How exciting.
Okay, well, that makes that one a lot easier then. So. But Laura, that leads to the next item then, because that is discussion and recommendation to change the ordinance language. So can they do that?
Fine, yeah, so that one, I know, I looked at, that's just making a recommendation to the planning
Okay,
commission. So anyone
perfect,
can do
okay.
that, that's not a binding interpretation.
Thank you. Okay, so shall we move on to the next one? Kate?
We're moving right along. Oh, thank you. I wondered why you were pushing at my face. Okay. The next item under new business is discussion on proposed changes to Appendix A, Article 20, Section 2007, and the zoning permit application.
So this request had been made at a previous meeting, the May 6th meeting. It was requested that the board review and consider changes to Article 20, Section 2007 of the zoning ordinance and permit application language. I did also include, and I apologize, I missed placing that in the description. I did also include the application that someone would complete and submit for a zoning board of appeals application, because both of these contain language that while the ordinance says, that the variance that's granted is good for 12 months, our zoning permit states that a zoning permit is good for 12 months. So this is how you wind up giving a variance and then issuing a zoning permit that's good for 12 months. So there was discussion about how we could address that and potentially correct that issue. So I've provided the language from Section 2007 and did some redlining with proposed language for the board to consider. And then as well as the language that is currently on the zoning permit application and the zoning board of appeals application that is highlighted in yellow where that is indicated on those applications, and looking for a recommendation from the board on making those changes.
Well, anyone want to start or come in?
Well, you were
I was
all over this one, so I think you need to start.
I get to own this, okay. So I am concerned about this because the language says no order of the board, and this is under the ZBA language, correct?
Correct.
No order of the board permitting the erection of a building shall be valid for a period longer than 1 year. I also wonder, no order of the board permitting a variance. I mean, it doesn't use the word variance. Why not? So
Yeah.
a variance or the erection of a building shall be, so it says that that's not supposed to happen. But things happen, and how do we protect ourselves from a variance is about to expire? Should the applicant be notified it's about to expire? And if they don't have the building permit, should the variance expire? And And should the board be notified that this is happening? That's the area of concern that I have, and we talked about this at the first meeting, I think, Laura, that you were attending, and.
We
Mr.
did
Eichelon
indeed.
said, you know, we could send something to the planning commission,
Mhm.
say we have these concerns. How do we, you know, what can be crafted that addresses these concerns or whatever? So anyone want to weigh in?
You're right, and this does not actually address those specific concerns.
No,
The language changes actually, I think, are in a lot of ways very good. And I think they do highlight more effectively that it is only for 1 year, but it does not address what happens at 1 year.
yeah, what happens at 1 year, or what happens at 11 months, or 10 months, or, you know?
The other thing is, and to your point, this only talks about the zoning permit. It does not talk about a zoning variance.
Right.
And where we ran into problem is the zoning variance
Right.
was set to expire.
Right.
The permit kept going, but
There was no permit.
they run concurrent. Well, the zoning permit was applied, right? Was
Zoning
given.
permit was applied at month 11. And there was no building permit until the following September.
And I thought there was language about building permit.
Well, there was, unless a building permit for such erection or alteration is obtained within such period.
And significant,
You know, significant, substantial, woo-woo, you know, I don't.
oh, I know, but
When
I don't think you can say. you know,
Substantial is a magical legal word, though.
An erection should also include,
A variance,
well, no, it's not just erection of a building, it's also modifications
Right,
and,
right,
Yeah,
Well, it does say alteration.
alteration. But I guess I think that you know,
in the first sentence, it does not.
No, it's the second sentence.
Mhm.
if you had to have a meeting to define, was there substantial work done? I mean, you're gonna waste a lot of time, you know, I think, I mean, in most cases, I think that.
but can you really define that?
That's what I'm
well?
saying, it's
Yeah,
very hard to define.
yeah.
So I think it's, my concern is you grant a variance, you shall have a year to complete the alteration or the building. I think the customer or the applicant,
Or get a building permit.
it have to get a building permit, should be notified in 2 weeks, you will expire. And if it expires, you have to come back to the zoning board
Mhm.
again.
I don't think you can, some jobs you can't get them done in a year, so the variance should keep going as long as there was a building permit and the work is taking place.
Right, I agree.
Okay.
Yeah, I don't think you can, I mean, I think there's projects going on that aren't completed and they probably have extensions for them, you know, so. So I think,
But if you have a project that hasn't been started, you want to have some method to be able to shut it down.
right, to say, come back to us.
Yeah,
Yeah, and that would be a building permit.
No,
well, no,
it would be a reapplication for a variance.
I'm sorry, if there's a building permit, then the extension happens if there's no.
no, it would be a building permit and progress
Yeah.
of however we decide to
Right.
define it.
One of the, well, they're two different things. If you get a building permit, you may not have started construction. Are we requiring that they start construction,
Yes,
okay, versus just getting a building permit?
yes, we're requiring that they start construction.
But then we have to define what starting construction is.
It's putting a ladder, a step
Yeah.
ladder in the
Well,
room.
it's just a single shovel in the ground.
Yeah, I mean, it's pretty.
And that's true. I mean, they shovel in the ground and they said that they've started construction.
For everybody's clarity in operation. We gotta make it as crystal clear as possible.
Yes.
And there it is. The variance was granted on this date. And they should be well aware, notified.
Within a year, they have to have a building permit. and a zoning permit, right?
Right.
And maybe they have to have 50% of the project completed,
Oh, I wouldn't say that at all. I
or
wouldn't require
25%.
that. I wouldn't require anything about construction. I would require the permits to be in place.
Yeah, I think
That seems
permits,
pretty
Then
soft.
wait 5 years to.
Yeah.
well, I don't know if. a
Yeah,
building
I don't
permit-
like-
Building permits won't last that long.
Yeah, that's.
So
they
we're
expired.
deferring that
What's
off.
the duration of a building?
They can get extensions. I don't wanna say indefinitely, but they can get extensions for
Yeah,
a significant amount of time. So one thing to consider is, and Laura, correct me if I'm wrong, but like there is language that I amended on the applications that states that, well, let me see, the revised language, I guess is what I need to read, would be the zoning permit is valid for 12 months from the date of the approval or 12 months from the date a variance was granted by the zoning board of appeals, whichever occurs first. And this is basically anyone coming in to get a zoning permit that didn't get a variance has 12 months. Anyone coming in with a variance then has 12 months from when the variance was granted.
Yeah.
That's going to secure it, and maybe it's putting, Laura, again, maybe that language should go in our ordinance.
So,
Um,
yeah, let me say at least three things, if I can remember them for that long. One, I likely agree that it makes sense to specifically reference a variance rather than just the, erection of a building. Shoot, I'm gonna forget one of the things. Oh, shoot, what was the other thing? I was holding all my thoughts in my head. I should have written it down. Oh, I would not put a requirement that the city provide a warning of expiration. That puts an unnecessary administrative burden on the city. And it's really the property owner's obligation to keep track of their deadline. They're told the
Right.
deadline. So to
Some
say,
property owners
yeah,
are like-
I wouldn't do that. Am I-
If you apply that theory, that the owner has to be an adult and know what's going on, that applies to lots of situations that we talk about.
I agree with that. My third overarching comment is I think we can, get language, as close to what you want as possible, recognizing, the planning commission can do what they want, and then ultimately city council can do what they want. So this is sort of an advisory suggestion, I think a valuable one. But ultimately the language is not going to be up to the ZBA.
Well, we know that, but I will tell you, in the past, I have called the Michigan Society of Planning Officials, because they will give you advice, if you have a conversation. And this one woman I talked to who'd been a planner, she'd been on boards as a ZBA person, talked about the language, and she said how important it is that it's very clear what the expectation is. So if your variance expires, whether or not we warn you, it comes back to the ZBA. And I think
It just
It
expires.
just expires. Yeah. If
They
they
don't
want
have
an
to.
extension, that's something that would perhaps come back, but, yeah, if it expires, it expires.
Are we gonna require that if their variance is set to expire, that they bring the matter back and they want an extension, that they should bring the matter back to
the ZBA.
the ZBA in a certain amount of time so that the ZBA has time to review the documentation, finding of facts?
Now we're assessing. Well, your kid was sick and there's this delay and that delay, so, is that the kind of criteria that we want to employ to decide? All right, we're gonna extend the period of your variance and now you can construct. Gosh, I thought it was, you made the request, it was granted, you got a year to get it going,
yeah.
have a nice life.
Yeah, I
So
don't think we want to complicate the process by
Right.
adding more things to it.
So does the zoning administrator have the authority to extend the variance or the zoning permit?
I don't think so.
Well, it should say that then.
Yeah, it does, it says it simply expires.
Yeah,
We don't have to put in, and the zoning.
Well, I think you
administrator
do
or
have to put
nobody
it
else
in because
can
that's
extend.
not. I think you do have to put it in because otherwise anything can happen.
Technically,
Well, I wouldn't be adverse to, I mean, it provides clarity to the city staff that this is it. There's no extensions.
Yeah, I don't think we have to put in that we need a time frame. They just have to come back and apply for a new one, period. And they can do that whenever they want.
So just
I guess they never
add,
did.
reply after next 12 months.
technically, Laura, hello.
I'm here. No, I'm here.
It's your baby doll.
When we have language that says shall, you
Mhm.
think of that as being binding, but it doesn't necessarily,
Get interpreted that way.
yes.
Well, shall will generally be interpreted as mandatory.
I
That's-
know,
Yeah, right.
Is mandatory.
but if it's,
You need to decide what you want to accomplish first, and we can wordsmith it, right? Like typically, if you're gonna have an extension, the rule is just you have to come back before it expires, right? You can't request an extension after it expires. Do you want that to be an option?
well, I think if it's about to expire, there shouldn't be an administrative extension. I think
No, I agree.
it should be allowed to expire and then they come back to the ZBA.
Yeah,
Well, that's what I'm saying. Do you want them to come back for a new variance, or do you want them to be allowed to ask the ZBA for an extension?
I think you could say, could it be considered, the process would be to come back either for an extension from the ZBA or a new variance if it's required.
Yeah, whichever way, I think you could do it, however you want to do it.
Maybe new variance is cleaner, you know, Bill would say it's cleaner. Am I putting words in your mouth?
Well, I mean, getting a new variance, it's just a much different standard perhaps than an extension, right? You've got to go through and re-show all the things you already showed. If it's a matter of, hey, we need another 3 months because there was, a global shortage of this supply, we need a few more months. Do you
Do
really want
remedial work to the soil,
I think
Yeah, do we really want to have to go through the entire process of a variance
then if they
again?
don't do anything, they gotta come back and ask for it again.
Yeah,
So that's what Jim said.
yeah.
It expires, do it again.
Well, I just said it, that it expires, and if they haven't done anything, but they want to, then they have to come back and ask for a new one.
But do you want to give them the option to ask for an extension instead of getting a new one?
I think they should just start the process again with Lisa and apply for a new variant. Because there
I
are
like
things,
that because, if they see, oh, I can go slow and
Yeah.
I'll just go back and.
I'll go
Yeah.
13 months and just ask for a little bit more.
Yeah.
Because things could change in a year that maybe we don't,
Bingo.
we don't want to give a variance for that,
Right,
for whatever reason.
whatever reason it
Yeah.
would be.
That's an excellent point. If the ordinances change,
Or the people in
And
the
it-
ordinance change and it's a different,
yeah,
Yeah.
well, I'm thinking more finding of fact.
Technical.
If the ordinance change, like short-term rentals, and come back and they haven't done any work, then it's a new
Mhm.
variance.
Laura, does that put them in a predicament if they approve it once and it comes back for the same ask and they deny it?
Well,
Potential.
standard is always whether it's supported by competent material and substantial evidence. So yeah, if you have the same evidence and a different result, I think somebody could argue that, not guaranteeing how that would come out. Maybe the facts are different.
sure.
Just throwing it out there.
Yeah.
An extension, they wouldn't have to argue the facts all over again of
Right.
why they got variance. The
Right.
new variance,
Set up criteria for, well, on what basis are we granting an extension now?
Mhm.
What evidence are we gonna demand? Are there specific criteria that will justify the extension? Or just, well, we like you.
Mhm.
is
I
it,
don't wanna be in that. ring.
isn't it the same
Yeah, it's the
checklist that we went
Well-
through? Before?
It's a different checklist, right? You're not gonna go through the variance standards necessarily for an extension, but it is going to be a reasonable discretion standard. You're not gonna do it because you like somebody. You're gonna look at what their facts are, right? Is there a legitimate reason why they need the additional time, or did they just delay and not get around to doing it? So it provides some, yeah, I'm not saying you have to do it. I'm just asking what you want to, just kind of fleshing out the conversation. You can recommend whatever you want.
If you denied, let's say you have the extension as an option.
Mhm.
You deny the extension because we think your reasons aren't valid. If you would like to come back and reapply for the full variance, you can do that.
Sure.
Is that
Yeah, you could do that.
legal? So should we craft something more specific for our next meeting? I mean, how does this work now? Or do you feel you can? You're so tired. Would you like?
Glad I didn't cry. So.
No. Oh, you would have been alone.
Could we all just have a quick cry?
So
Why don't she or one of us come up with the language and present it at our next meeting?
Would that be helpful?
So we would be real, this is big, important stuff.
Yeah,
that's fine.
Go for
Is that
it.
all
You
right?
should do that.
So the
I
June
thought she was
17th
good.
meeting.
So you could do it, Lisa, incorporating these things that we've talked about, and maybe, like Laura suggests, you could have option A or option B or option C.
Yeah.
And then we could see that those address these kind of essential things that we care about, are concerned about. How does that sound?
Yeah.
Everyone's like,
That's a deal.
Whatever. Sounds good.
yeah, whatever.
Read anything at this point, yeah.
that sound good for you, Laura?
Sounds good to me.
Okay, so that's that, and now we have any board member comments or questions?
Well, let's get it.
Anything? There being none, this is your last opportunity.
So wait a minute.
Wait a minute.
On page 60,
Yeah. Okay.
160.
So,
I just want to read 50
yeah,
pages.
so I just to be clear, we're trying to decipher whether there was substantial work done before December 18th. When we go back and look.
Well,
at
is that when, December 18th is when the,
Moratorium was-
is that when the moratorium starts? Cause I had.
No, it's when the ordinance took effect. That's the relevant date.
Is when the yeah, the ordinance took effect December
All
18th,
of the work,
but the moratorium started July 23rd,
uh,
July
November
23.
November of 22 to July of 23.
And July of 23 is when the moratorium started, right? That's what I heard.
Is not,
Could anybody do a timeline?
Well,
a graphic
that's why
timeline?
I like, when I
Anybody
was
that
reading through, I was
has
trying
good
to do.
graphic skills
Are
that
you
could
thinking?
do it. Because I can't, they know every
Oh,
date that they
Well, and then.
cross the street and I can't keep track of
Well,
that.
I
They
think
do have
the
two
good question-
timelines that they submitted.
Yeah, the good the question that I think is relevant to what Jim was saying too is, does the work have to be done before the moratorium? Or before the ordinance took effect?
Before the ordinance took effect. So that's
Okay,
right.
so
That's
it had to be done before December 18th of 23
but they said they stopped work.
in July.
You're saying that they, Laura, you're saying that they could have continued with construction even during the moratorium period?
Yes. And that's, I'd say that's for a couple of reasons. One, just frankly, the enactment of the new ordinance is the magical date for purposes of that use. But also the fact that they were doing this work, I'm sorry for the background noise. I've got kids.
We don't hear it. We can't hear it.
Can't hear it.
Okay. All right. No more puppy toys for you. The fact that there was a moratorium in fact doesn't mean you can't do work on the building. I mean, you can't get approval for the use, you can't engage in the use, but you can put bedrooms in a building. That wouldn't have been precluded by the moratorium. That wouldn't have been unlawful because of the moratorium.
But they claim they were not doing it during the month.
Oh, and that's fine. I'm just saying there's not a requirement of the court that you exclude any work done. If there wasn't any, then there's nothing to consider. But if they did something during the moratorium, you would be allowed to consider that.
Right, okay, so any vested interest considered work would be done before December 18th of 23. Right.
Correct.
Hello, what kind of dog do you have there?
I thought that was
I
the
have
baby.
I have a mini poodle. There's his Zoom debut there. Oops. Yeah. So.
Okay, well, are we good? Are we adjourned?
No.
No,
You're not adjourned, but no, not yet.
Absolutely, I moved to.
He moved.
adjourn.
I'll second.
all agreed?
Aye.
Thank you.
Thank you,
Ronnie.
Laura.
And-
Absolutely. I'll see you in 2 weeks.